record, Ms. Wilson.
Abigail Wilson for the people.
Mr. Koontz.
Yes, good morning, Your Honor. Dustin Koontz for Eric Nichols, who's standing here to my right.
And sir, you are Eric Nichols, is
Yes,
that correct? All right, thank you. So this is the time set for a jury trial in the matter. I'm going to pull up some instructions to read. I'll share them with you. They should be up there. All right, ladies and gentlemen, I'm Judge Tony Flores. It's my pleasure and privilege to welcome you to 54A District Court of Hingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both the person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. We'll be picking 7 today for this case. One would be a replacement. Jurors must be as free and as humanly possible from bias, prejudice, or sympathy for either side. Each side at trial is entitled to jurors who keep open minds until the time comes to decide the case. The trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out that you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They're not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there's a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully and honestly all the questions that you'll be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. Members of the jury, would you please rise? Raise your right hand or take an oath. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case?
Yes.
All right. Are there any negatives? All right, you can have a seat. Thank you. I'd like to introduce you to the members of my staff. Wendy Holden is my court recorder. You'll see she's responsible for making sure that there is a transcript of this proceeding. All right. So you may occasionally see her say things to me like I can't hear juror number 4 or something along the lines of voir dire. It's not meant to penalize you or to make you feel unwelcome. We're just making sure we have a transcript of this proceeding. My court officer is Nathaniel Neves. He will be responsible for taking you around. I will swear him in at the end of the trial during your deliberation process, okay? This is a criminal case involving the accusation or charge of malicious destruction of personal property, $200 or less, which I will explain more fully later. I'll walk you through the complaint, okay? This charge has been made against the defendant, who is Eric Nichols. The defendant's lawyer is Dustin Kuntz. Please introduce yourself, Mr. Kuntz.
Thank you, Your Honor. Good morning, folks. I'm Dustin Kuntz. I have the pleasure of representing Eric before you today.
The lawyer for the state of Michigan is Assistant Prosecuting Attorney Abigail Wilson. Ms. Wilson, please introduce yourself and list any witnesses you anticipate calling in this trial.
Thank you, Your Honor. Hi, everybody. As the judge says, I'm Abigail Wilson. I'll be representing the people today. Today I intend to call Curtis Pierce and Officer Joseph Traverso.
Does anybody know of any of the witnesses that were just indicated by name? All right. We think this trial will last about 1 day. This is about a 1-day trial. If you believe the length of the trial will be a real hardship for you, please let me know right now. Would one day in this court provide a hardship for anyone? All right. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? I don't know if it'll be that long, but so ma'am, that may cause a problem for you.
Yeah, I have severe ADHD and can't sit for very long and focus.
All right. And the jury's aware of that. The attorneys are aware of that. We'll go from that when we need to, okay?
Thank you.
Does anybody have any sight or hearing problem that may be an obstacle? Nothing to be ashamed of, but be an obstacle. I think they would agree, both lawyers would agree, we want the jury's full focus to be on any witnesses and any exhibits. Does anybody have a problem in that regard?
I do wear hearing aids.
All right. Remind us of that when we pull you up, and we'll see if it presents a problem. You are sitting next to the witness, so you should be able to hear. But if you cannot hear for any reason, let me know, okay? All right, thank you, ma'am. This is a criminal case. The paper used to charge the defendant with the crime is called a complaint. The complaint in this case charges the defendant, Eric Nichols, with the crime of malicious destruction of personal property, $200 or less, and reads as follows. On or about October 2nd, 2023, at the defense location of 1918 John Street, City of Lansing, Hingham County, State of Michigan, Eric Nichols is accused of willfully and maliciously destroy or injure a lawnmower hood and cameras, the personal property of Curtis Pierce, and the amount of the destruction or injury was $200 or less. A person is accused of a crime is presumed to be innocent. This means he must start with the presumption that the defendant is innocent. The presumption continues through the trial until and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. So I will now draw your names since I have them in front of me. As your name is called, please come forward, take your seat in the jury box. So the first juror will have the longest to go because you'll have to climb over everything. We are getting a new courtroom. They told me that, okay? We're getting a new building, but I don't know when. So juror 1 would be the farthest, juror 2, 3, 4, 5, 6, 7, all the way up front. So fill in the rows, and then we'll start the voir dire process, which is a process where both sides get to ask you some questions, all right? All right, the first juror that is selected as juror number 1 would be Victoria Perkowski. Right, Ms. Perkowski, you get the inevitable task of going through all the chairs. Juror number 2 will be Kelly Rogers. So Ms. Rogers, you can fall right behind Ms. Perkowski.
Thank you.
Juror number 3, Jeanne Garris. Okay. Juror number 4 would be Deborah Underhill. Juror number 5 would be Connie Billa. Juror number 6 would be Maria Morales. And then juror number 7 at this time would be Mitchell Huffnagel. We've already heard from a couple of the jurors already, but I'll let counsel ask their questions. Ms. Wilson, are you ready for voir dire?
I am, Your Honor. Thank
Okay,
you.
you may proceed.
Hi, everybody. Thank you for coming today. I know it's kind of inconvenient sometimes, but this is a really important process, so we really appreciate your participation today. So as Judge Flores said, my name is Abigail Wilson. I'm the assistant prosecutor on the case today. So I just kind of want to have a bit of a conversation with you about the case, about the law, and about your feelings about everything. So an impartial jury is the bedrock of a fair trial in our system. So this is a bit of a ridiculous example, but if somebody has, a prejudice against people with beards, thinks all people with beards are criminals, they probably shouldn't sit and determine whether or not somebody with a beard has committed a crime. So that's kind of the stuff that we're looking for today. It's a little bit more subtle than that, but just kind of broad picture. So I'm going to ask you some questions today. They might feel a little personal, maybe feel a little probing. My purpose here is not to attack you, not to embarrass you, not to judge you. I just want to get kind of an idea of whether or not you're somebody that might be a good fit for this jury. So that being said, there are no wrong answers. The only wrong answer is a dishonest answer. So just bear that in mind. And I do want to point out to you today that the oath that you just took is to tell the truth. It's not to follow the law. So at this point, if you have an issue with the law, it's okay to tell us. And in fact, you probably should tell us, because that would definitely bear on whether or not you're a good fit for this jury. So with all that in mind, I just kind of want to start out. So during this process, I'm going to tell you a bit about what I think the law says. Now, Judge Flores, after everybody is impaneled, will give you a description of what the law is according to the judge. Can everybody agree here that if something I say differs from something Judge Flores says, you'll follow what Judge Flores says? Anybody not be able to do that? All right. So has anybody ever been involved in a criminal case before as a defendant, a witness, or a victim? Yes, sir. What, do you mind telling us a little bit about that?
This is almost embarrassing. Sorry. A buddy of mine got jumped in a bar. I was underage at the time, but I was at the bar, helped him out because I was worried he was going to get killed. And then I was arrested. The police report was pretty insane because I had a father's friend who's in the police office in Chicago, and we got it expunged and all that kind of stuff, like eventually justice won out, right, but it was a pretty horrific process.
All right. So you said it's a pretty horrific process. So what kind of taste does that leave you about the justice system?
I think that there's a lot of, I don't know, blind weight that people can put into certain opinions if they come from people and certain authority figures. And I think sometimes that the data can point to the fact that that's not really the case. And so ultimately, I would say that I have I would call it a reasonable doubt, of things that are maybe supplied by people who are representatives of the state, because they don't always have all the facts, or sometimes they're incentivized to twist the facts, stay on overtime longer into an evening, things like that, ultimately. Okay,
thank you. Does anybody kind of echo those opinions? Right. So as the judge said, this is the malicious destruction of personal property case. Has anybody ever had their personal property destroyed by another person? Can you tell me a little bit about that?
This is juror number 4, and the previous was juror number 7.
We can call it boyfriend gone bad. So I had ski equipment, clothes, some items at the individual's home that when I canceled a weekend and went to pick up my stuff, everything had been destroyed. Crazy stuff. Clothes cut up, cigarette roll burned in them, ski equipment totally ruined.
Did you file a police report in that
I
case?
did.
And what happened with that?
Nothing.
Nothing? And how do you feel about it not going anywhere?
Well, I filed a police report. The person called me repeatedly. I talked to my attorney, they called them, got a cease and desist, and that was it.
Okay. So with you having been in that situation, do you think that you have any sort of feelings either for or against somebody that might be charged with a similar offense?
No. It's like, oh.
Okay. Anybody else? No? All right. So let's pivot a bit to the burden of proof in this case. So the judges instructed you a bit that the burden of proof here is beyond a reasonable doubt. Can anybody explain the difference to me between beyond a reasonable doubt and beyond a shadow of a doubt?
I have no clue. I'm very comprehension dyslexic, so not all words and things that people say make sense.
Okay, does anybody want to take a stab at it? How about juror number 1? Okay, so if I were to tell you that beyond a shadow of a doubt means that there's absolutely zero doubt in your mind, does that make sense? Okay, now if I were to tell you beyond a reasonable doubt means that maybe there's a doubt floating around out there, but maybe it's not based on facts or something that's really reasonable. That means that, you know, if, again, it's an absurd example, but if you're thinking maybe aliens came and did this instead of the person that's accused, it might not be a reasonable doubt. Can everybody kind of see the distinction there? Okay. Does anybody disagree with that? Does anybody think that they would not be able to return a verdict if they had a reasonable doubt? So can everybody agree that if you were to sit on the jury here today, you would abide by the standard of beyond a reasonable doubt and not hold me to the standard of beyond a shadow of a doubt? Can anybody not agree to that? All right, so let's chat a bit about what has to be proven beyond a reasonable doubt. So in this case, there are a couple things that need to be proven in order for you to return a guilty verdict. First, that the defendant was the person that committed the offense. Second, that the defendant damaged personal property that belonged to someone other than him. Second, that he did it with intent and that he did it with the intention to damage that property. And then we also have to prove that the damage was either $200 or less. So examples of things that don't need to be proven: the weather that day. If there's a discrepancy in the testimony, maybe somebody says it was raining, somebody says it was sunny, is that fact something that needs to be proven beyond a reasonable doubt? For number 3? No? Okay. Does anybody think that it does? Okay. So let's say you have that discrepancy in testimony. Somebody says it's raining, somebody says it's sunny. can you consider that discrepancy in any other way? Anybody think of anything? Juror number 6, can you think of anything? No? All right, so what can it tell you about a situation where two people can't agree on a basic fact? Maybe one person's more accurate than another. Yeah. So if there's a discrepancy based on a fact that doesn't need to be proven beyond a reasonable doubt, is that something that you can consider in maybe determining whether somebody's a reliable witness? Juror number 5?
Yes.
Yes, okay. Does everybody agree with that? Does anybody disagree with that? So I mentioned that one of the elements of this offense is the extent of the damage, and that has to be $200 or less, but it has to be some value. So if the proof was that the damage was $0, does that fit that element?
Yes.
We sure? It does not. So the instruction you're going to get is some value less than 200. So it has to have some kind of value. So $0 would not be a value because it's worth nothing. But if the damage is worth 1 cent, does that fit? Yes. Okay. Now, 1 cent for a lot of people might seem kind of petty. Let's be honest. I'm not saying the damages in this case are 1 cent, but if they were something, low like that, the law does provide for a remedy in that case. Would anybody have any qualms about returning a guilty verdict if the damages were as low as 1 cent? No? Okay. Anybody else? Anybody yes? Okay. So is anybody here a mind reader? No, I didn't think so. So if none of you are mind readers, how are some ways that you can determine somebody's intent? Do you remember one? Can you think of anything?
Just I guess based on actions. And stuff.
Okay, yeah, definitely. So one of the things that you're going to be instructed is what evidence that you can consider. Somebody's actions are definitely something that you can consider. You're also going to be instructed about what can be shown for intent. You can infer intent. You don't have to be a mind reader. You don't have to have somebody say, hey, I intended to do this. If the actions or whatever the evidence of a person implies that they intend to do something, that is sufficient under the law. Is everybody okay with that? Does anybody think that they would need some kind of more tangible proof of intent? Can you all agree to look at the evidence and determine intent based on whatever evidence is provided? Yes, okay. So has anybody ever heard the phrase, oh, that case is just circumstantial, or oh, they can't make that case because it's all circumstantial? Anybody? So can anybody explain to me what circumstantial evidence is?
The person was at the place at the time that something occurred.
Yeah, that's a good example. So circumstantial evidence is something that it's not directly apparent. It's something that you can infer evidence from. So let's say you got here this morning and it wasn't raining. Then later you see someone get here and they're wearing a raincoat and they have splotches of water on them. Can you infer from that it's now in fact raining? Okay. And based on that situation I just described to you, would you be comfortable inferring that it's raining?
Yes.
Okay. So in this case, you might be presented with some circumstantial evidence. Does anybody have any issues with evaluating that evidence and giving it weight and consideration? No? Okay. So let's talk about witnesses a bit. some witnesses get a little heated, a little upset. It happens. So maybe you see a witness and you're like, I don't really want to be buddies with that person. They're not somebody that I really would enjoy hanging out with. If this person is somebody that you maybe dislike, can they still be a victim of a crime or still be a credible witness? Yes, okay. Would anybody have any issues with maybe putting aside their personal opinions about the personality of somebody in order to make a fair determination based on the evidence of the case? No? Okay. All right, that's all I've got, Judge.
All right, thank you. Mr. Coons.
Thank you, Your Honor. Morning, folks. I typically look for volunteers first, so chime in if you have any thoughts. Does anybody have any thoughts about why we do jury trials in America?
Fairness.
Thank you. Juror number 4, Ms. Underhill, is that right?
Yes.
Fairness, how so?
Well, if one person determines the outcome of another person's versus a group of people.
Sure.
Because everybody has different perspectives, different possible biases.
Okay.
Hear things differently.
All right. Agreed. Anyone else have anything to add? We could do it another way. Does everyone agree with that?
Mm-hmm.
There are other ways to try cases.
Yes.
Police officers could make the call on the scene, right? Well, ma'am, scene number 5. You say no. Tell me about that.
Well, it's not the role of a police officer to decide innocence or guilt. That's not their responsibility.
Why
That's
do,
why we have a court system with either a jury trial or a bench trial, which your bench trial is where you strictly have the judge making the decision.
am I right? You're a legal assistant?
I am. sir.
Okay, it's showing. Where do you work?
Troon Law Firm.
Okay, okay. You work with Phil Clark?
Pardon?
Phil Clark, you work with him?
Yes, I do.
Oh, okay. I'm from law school.
Yeah.
And he's much better at hockey than I am.
I've heard that about not specifically you, but I've heard he's good at it.
Yes, that's exactly right. So we have the system we do. I mean, you think it's fair to say because sometimes the government could get it wrong?
Sometimes I think they can, yes.
Sir, in seat number 7, I saw you nodding your head just now.
Yeah,
Do you want to add anything?
I would agree with that. I think that the government is no lock of getting it right on the first time or the second time or third.
And I don't want to probe too deeply into something that was traumatic for you, but it sounds like you don't agree how your case was handled. Is that right?
No, it was handled poorly. The gentlemen, 2 of them who started the fight with a buddy of mine, they're the ones who then pressed charges. And while we were waiting for the police officers to get there, they kept sending their girlfriends into me to say, if you give us your friend's address, then we'll drop the charges and we'll go just visit your buddy. And obviously didn't go for that. The police didn't really seem to believe the accounts that we had. They wrote in their report something about how I had like a knife and was throwing stuff across the bar like it was some Western or John Wayne thing, was how it was described to me by the police officer who took a look at the report. It was a pretty horrible experience to understand that you can do. I was at a bar underage. I should have gotten in trouble for that. But I shouldn't have gotten in trouble for anything else that night. And that was pretty horrific to live through for a period of time, and the amount of money it cost to like get that off my record and get that expunged. And that experience was like very negative and opened me up to maybe taking a deeper look at how I view the justice system.
And so is it fair, I guess, to surmise that you ended up charged with a crime because of what some people told the police?
Yeah, and if you look at the time of day it was, those cops were coming off of their shift in about the next 20 minutes. And instead they got a few, I don't know, 4 hours of overtime driving me to the hospital and then taking me to lock up and stuff like that, you know, which obviously they're incentivized to do per their paychecks. So that was pretty difficult experience.
Did they take your side of the story?
They took it down. Yeah. It didn't seem to make its way to the report.
Anyone else think the government can't get it wrong? That if somebody well, first of all, can somebody lie to the police?
Yes.
Seem agreement now. And I don't think this is the case here, but can a police officer also be less than truthful?
Yes.
They're humans, right?
Yes.
With human fallibilities. And see number 4, I hope I'm not speaking ill of your husband. He's a retired police chief, is that right? Where at?
Where was he, police chief?
Yes, that's right.
He was the police chief in Grand Ledge, and prior to that, he worked.
Okay. I mean, did he shop with you? Did you talk about his work at all?
Occasionally, I was brought up with one. Father was also New York State Police and police chief, and brother was in corrections. So a lot of it.
Sure.
But yes, we talk occasionally.
Are you aware of any cases that any of your family members who are in law enforcement ever had where garbage in, garbage out, does that phrase mean anything?
No.
Meaning
I mean,
if,
I've heard the phrase.
sure. To your knowledge, was there ever a case where it seemed like maybe they were where a complaining witness was less than honest with your family members who were in law enforcement?
Not that I can recall where.
See number 2, I heard you, well, I didn't see who said it when they were in the gallery. Are you the one who said you have ADHD?
Yeah, I have a real hard time saying stuff.
Okay,
We're focusing,
now ADHD you can be hyper focused too.
but not on what people say, because I don't understand a lot of people say. I don't understand a lot of words.
Okay,
Like honestly, there's been about 20 words that I don't understand that either of you said.
okay. Now we're going to have some regular folks up on the witness stand testifying. Do you think you'd have a hard time understanding them at all?
It can vary.
Okay.
You know, I can't, I have comprehension dyslexia, written dyslexia, math dyslexia, everything's backwards.
Okay. Are you uncomfortable sitting on a jury then?
Yeah, I'm uncomfortable sitting in this box right now, and
Okay.
I feel very cramped and very hot and panicky.
All right, I'll leave you alone. See number 3, so you've got a mask on. I'm getting over a sickness, negative COVID test, but are you uncomfortable being in this courtroom?
I mean, generally, I think everybody should still be masking, but that's my own personal preference. But like, I also have to be other places.
I don't know if we heard juror number 3. So now just speak up a little bit. What did you say?
I mean, I think everybody should generally be masking more often, but obviously I can't control what other people do, so being here would be the same as being in a classroom
Okay.
or whatever.
I just want to make sure that we had a record of that.
Thank you, Your Honor.
Thank you.
Is anybody else uncomfortable for health reasons, sitting in a jury, sitting on a jury. Is all bad behavior criminal behavior?
We'd all be in jail.
The courts would be far busier.
Yeah, can someone think of an example of maybe something that's I don't know, not socially acceptable, but also not a crime?
Throwing a temper tantrum as an adult in front of police, it's no bodily harm or injury or public property destroyed, but it's not something that you want to see an adult person throwing a temper tantrum.
Fair. And I think Ms. Wilson touched on this a little bit in her voir dire, but whoever's sitting on the jury, you might not really care for any of the witnesses based on what you see and hear. Can you separate that from what your duty is? Surgeon number 7, I see you nodding. So you're going to be given a charge. You have to decide the facts and whether the facts meet the charge here. If you think my client acted poorly, can you still decide whether he committed the crime he's accused of? And see number 5, I see you nodding your head. See number 1, what do you think about that? I'm sorry?
Yeah. Just necessarily.
And for the court reporter's sake, not just because they acted poorly doesn't necessarily mean they committed a crime, is that right?
Yeah.
There's some talk of circumstantial evidence earlier in the example. I think it's normally an awfully good one is somebody comes in, the raincoat, umbrella, it's dripping wet. That might be circumstantial evidence of it raining. Is that fair to say? What if the high is 31 today? Get freezing rain. I'm sorry?
Could have been snow that melted.
Snow that melted. Could have been water elsewhere, coming from elsewhere. So there are reasons other than maybe the most, I guess the easiest explanation that could point to certain evidence. The obvious, yeah. Yeah, folks, that's all I have for you. Thank you.
All right. It's my understanding we need to take a break. So we'll take maybe, I don't want to get you up and move you all over. So we'll just take a 5-minute break for the defendant, and then we'll come back and we'll continue the case. Okay.
Thank you, Howard.
Thank you.
Yes, sir.
All rise.